All right, we're live.
All right, we're back in Judiciary Committee, still on S6 and over to the Department of State's Attorneys.
So I'm going to be exceedingly brief after going, after Tucker and all the other witnesses you heard, and the growing trend of me being here in the afternoon. You guys have heard a lot of great testimony already, I think, from lots of different angles.
And you have to identify yourself. I forgot to mention that part.
Tim Leader Dumont from the Department of State's Attorneys. I thought I was going to get away with it this time. And I wanted to share just a very brief personal story. My dad was a public defender in Addison County for many years. Back then, there was a group of public defenders that would trade cases, basically. So my dad would get a lot of cases in Windsor County. And my mom and dad actually basically met on a case, murder case in White River Junction area, Hartford. Where an individual with limited intellectual developmental concerns were all kind of at play. This was many years ago. And there was no recording of the interview, et cetera. And it led to, basically, so you were there, you did it, blah, 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 blah. Woman was killed. And there was an admission, for lack of a better word, although I think it was just transcripted, right? So there was no recording. And so much has changed from that time. He was found not guilty because of very faulty, actually, I think it was mud analysis, something like that, that ended up being very faulty. A UVM professor actually assisted in that. All this to say, I think state's attorneys, particularly, prosecutors that are embedded in the local communities are so invested in getting the right evidence in. We see our roles as gatekeepers. People call us prosecutors. We are the gatekeepers. Cases that you'll never see, that we said, talking with law enforcement. And as Detective Sergeant Cota mentioned, and as I know Commander Raymond will talk about, there's so much that goes into it before we see it. And then even at that time, sometimes there's a lot of back and forth. And then once it gets a docket attached, the judge has found probable cause. So there's a lot that kind of goes into all the steps that happened, prior to. And as you're thinking about, changing some of the case law that's been relied upon and that has found its way into motion practice, really the rule book for prosecutors, that when you change some of the rules, and this is not to sort of say for or against, you sometimes can create a slow intake of that information. So if this becomes law on July 1st, our training will be in June this year. So I'll have to say that this, if this were to pass, this is what's going to be happening. Lots of questions. And then courts will have to suss out the details and the areas in between. And I've talked with this about the chair before, but the concept of institutional consistency helps with things like backlog, training, competency of legal work. And there is fairly robust case law on this topic, that, as noted by Tucker, who gave a law review of this bill. He really did an exceptional job. So I would like to note that we do see that the burden of proof in one section of the bill relating to really the law enforcement side, preponderance of the evidence is used, and then later on it's clear and convincing. And we do think, consistent with a couple of the other states that have done this, Delaware and Illinois, preponderance of the evidence is probably a more helpful tool given all the other testimony we've heard. And I just wanted to note, preponderance can be described as imagine that you're weighing the evidence of the respective parties with a balanced scale. So it's a lower threshold. Clear and convincing evidence, which is contemplated here as something that prosecutors would have to litigate, is substantially more rigorous than a preponderance standard, higher probable sort of standard. It is not met unless the evidence results in a firm conviction as to the truth of the allegations to be established. And I'm mentioning that just because it starts to, you hear that, right? Almost feels a little bit like something a jury should be thinking about. And I also wanted to note, given what you were talking about, Representative, the role of the jury that they play, and there is the different things that come into this. And just like when you have a confidential informant, or in the organized crime context, an individual that flips, the jury is looking down at that person and has to kind of do their analysis. Likewise, with a recorded interview, they'll be able to hear that and do their analysis as to the credibility of that person. and whether or not what they're saying should be accepted as fact worthy for the purposes of conviction or not. And having done a couple of voir dires of juries, there's nothing more intimidating for a prosecutor to talk with 12 people from your own community. I don't know what it is, but it's like being a comedian and no one's laughing. It really is quite an incredible experience. And I do think that the jury system that we have really does tackle some of the loose ends here. I did want to note that there is tremendous issues across the country with some of this. As we've seen, the Innocence Project has done an incredible job, particularly with the DNA evidence that they've been working with the last 30 years, where there's DNA evidence and a false confession. It's beyond egregious. It's not acceptable in any state where those have happened. And here in Vermont, I do take a lot of confidence in how far we've come in my lifetime from talking about that instance that my parents were involved in before I was born. But also that we have, practitioners that have come in talking with you about their tactics. And I know you'll hear from the commander as well. So other than that, I'm happy to chat. We do think this is mostly a law enforcement related, we're receiving it further down the line, and then we do what we do in the court. So it's kind of sound like Judge Zone a little bit. It's hard to say how it'll impact what we do until this is passed, but I think it might have some impact from a training perspective, but also in terms of the results for victims potentially. And the two case categories that you've been hearing about, kind of the internet-related crimes and sex-related crimes, and also some other crime types that Tucker was discussing. There is some data that I'd be happy to try to share afterwards that individuals that engage in internet-related crimes are very likely statistically to engage in some of the in-person behavior as well. And sometimes the two are very merged. As a hypothetical, a 21-year-old is engaging in mentoring of a young person in the community. Perhaps at the middle school, the relationship turns into something inappropriate. It starts online or has an online component, and then it takes years later for it to really come to light. And so there is certainly improper uses of deception, but there's probably really important law enforcement purposes for deception as well. That case-by-case analysis, I know that's a very easy fallback, but it's an important rule that prosecutors use when looking at the evidence and deciding how to proceed forward with serious cases that I know we've been talking about. But nothing really further than from here, other than I appreciated a lot of the comments made by both the detective and also from Attorney Jones. So it sounds like you're not in favor of the bill as it is right now, but you haven't come right out and said we oppose it or are for it. I just want to. Other than getting all 14 states' attorneys to come in and talk about it, I think we have taken a little bit of a wait and see approach with this. I think we do see an issue with the burden of proof from our perspective. And we do think it should be preponderance if it's going to be passed to be consistent with Illinois and Delaware. And we do see this could have an impact on important cases where, as I think Tucker was talking about, an individual law enforcement might, during the investigation phase, be engaging in some deception and online behavior, posing as a young person, for example. And then the custodial interrogation takes place, and that deception might need to continue. For example, you were talking with 13-year-old named, Bobby, weren't you? Well, no, he was talking with a police officer. But to continue that deception, that's an important law enforcement reason, so that you're not just saying, hey, that was me the whole time, right? The ruse might need to continue for a little bit longer so that the individual can have the opportunity, as, Tucker was saying, to, engage with whatever the methods being employed, whether it's the peace method or not. There may be a reason to continue that. So you were talking about potential exceptions, whether it's the ICAC cases or sex-related cases. That, I think we look forward to seeing some of that language. And, on the age question, the bill originated as an 18-year-old conversation on the Senate side. We'd certainly be happy to look at language if it were to be lowered so that you're taking an incremental step as opposed to a slightly larger step in a larger population. That's really my comment. Sorry if it's a little bit vague. I think it's a little bit of a moving target right now.
Ella, then Angela.
Thanks. It's really helpful to hear your perspective on this. I was hoping you might go a little bit further from the sort of prosecutorial role. We've heard from law enforcement about scenarios where they're concerned there'll be a lack of sufficient evidence to put someone who is guilty, to hold them accountable. So I guess I'm wondering from the prosecutor perspective whether you can think of examples where that case hinged on that kind of information and might not be able to be, have the same outcome if we were to pass this.
Yeah, and I would largely defer to some of my law enforcement partners who really have engaged more in that in-person thing. We're seeing it on paper later or sometimes a video. But I was just responding to a public records request about a very famous case up in St. Johnsbury. It took place about 10 years ago, where there was aspects of deception that were employed to confess to a murder of a school teacher up in St. J that had aspects of deception. And the definition of deception that you're using here, on the Senate side, there was a question posed by Senator Hashim about the circumstance that I was just trying to describe, not very artfully, because really Commander from AG's office would do better at doing so, but that deception is happening in the investigation stage. Now you're in a room, there's a recording device happening, it's a custodial interrogation, you're not free to leave, you're 21 years old, and you're talking about a serious case. The officer might still would deception kick that out of a potential case proceeding? And the answer that I think the Senate arrived at was yes. It would kick that case out if deception were used potentially. And so that's just a potential side effect of this. And I think it would have to play out a little bit in each case as it played out. And I know it's hard to really put your arms around all the different types of ways that this could happen in the courtroom. But that is a concern that I've heard from law enforcement. And so I have to kind of rely a little bit on what they've said too, because we're getting it once it's received that initial kind of circumstance.
When you said kick that case out, what do you mean exactly?
So if deception is being used during the custodial interrogation in the same way that it was used during the investigation, basically not admitting to whether or not they were the person that they were purporting to be online, for example.
No, I just meant to kick the case out. What does that mean?
The case might be, the evidence might be suppressed and the case would not be able to move forward.
Okay, that's it. That's all I want. Yeah, I just wanted to make sure.
Excuse me, the 4 o'clock term.
No, fair enough. Are you good, Ella? Do you have a follow-up?
That's fine.
Angela.
2 4 o'clock questions. First, might have lost the first one. Okay, I'll go with the second. We've heard from a couple of witnesses that the deception as a tactic is just not allowed for attorneys or judges. I think the term this morning was, it would be unconscionable for a judge in particular to utilize some form of deception. Have you had experiences in your professional life as a prosecutor where some sort of deceptive tactic could have been really useful for you?
I mean, no, because it would disrupt quite a few things down the line. The potential, if I were pursuing the best outcome for the case, for example, people think that's a conviction. It's not a conviction. It's really more of what's the outcome for the case. If I were to use deception, for example, to get someone to plead to something, it's where we do a lot of negotiating. It would potentially injure the finality of it because a post-conviction relief case could occur. So deception would only hurt me. In fact, what ends up happening, as my colleague over here knows, is sometimes the defense side gets accused of ineffective assistance of counsel years later, and then the prosecutors end up defending the finality of that case all over again. And so deception, whether it's prosecutor, defense, judge, would only hurt what we're trying to pursue, which is the ends of justice, the means of justice. When it's still in the fact-finding investigation phase, and as Tucker said, for I can remember not wanting, both my parents were defense attorneys. They would have been fantastic prosecutors. And I know what it's like to be accused of something that I did and didn't do. And so I can totally understand why, when you're investigating something, why you may want to say, isn't it true, when, maybe the officer in that moment thinks it is true. They find out 2 days later, oh my gosh, it was 3 a.m. in the morning. I was questioning this person, right? There's some ambiguity in the deception part of this statute that I think might lead to, as I've said, something getting suppressed and then not moving along. But from my perspective, I can't think of a single circumstance, both from an ethics perspective or a finality perspective, where deception would be at all helpful to me once I get the case.
So it's curious to me that we wouldn't apply a similar ethical measure instead to the investigative process.
I think there's a distinction between ethics and if the purpose of the interrogation is to continue to find facts, whether you're trying to ascertain what happened or whether there's evidence of it and you're trying to get the individual to confess to something. If you're still fact finding and you're using a good reason for some aspect of deception, I do think it's different, because once the case gets to us, even if there might still be some evidence gathering that happens, if that was the only thing they were getting upon, confessions or evidence there's no physical evidence, no corroborating evidence, no other witnesses, then we have to make that call as a prosecutor. Is this really a good use of public resources to pursue this case where, let's say that there was an exigent circumstance, the recording device wasn't turned on, which is one of the exceptions to using the recording device, and the officer says, I know you were there last night. There's video evidence of it. And then there's no video evidence of it. There's no other corroborating evidence. There's no cell phone records. There's so many tools we can use in 2023 to corroborate things. As stated, 30, 40 years ago, there was less of that. And so I do think there's a lot that the state can do to corroborate what's said during, a confession, or just the further ascertainment of facts. But I understand what you're saying. For me, it feels different. I have an ethical duty to pander to the court. Law enforcement officer has a duty to try to find the facts of the case before it even gets to me, or when it gets to the sort of criminal justice track process.
Right. Though you did identify as your goal justice, and I believe I heard that was the goal of the police officer as well. So I'm struggling with the idea that we would all have the same goal and allow this tactic at one point, and then at some point it becomes unthinkable. No, we would never allow that here. But just before that, yes, totally necessary. In fact, we can't really do our jobs without the use of deception, and I'm really struggling with that.
Yeah, no, I mean, I think it's a difficult point, because you can't wrap your head around all the different circumstances where it may be helpful. And as I've stated, it might be helpful for me to get someone to plead guilty to something, to use deception, but for me to actually have the state of Vermont understand that the case is going to be final, that I didn't, mess with some bit of, we're gathering more evidence, Mr. Paul, on your client. We actually have 5 witnesses. I'm lying in court, right? I can't do that. But when an officer is trying to figure out what happened, and they say things that might be deceptive as a broad term, because it is a little bit broad here, in pursuit of truth when the facts are still coming at you, that's something I think is a different context, as opposed to now we have probable cause, we're pursuing it with the judge signing off on it, and we think that it's a case that merits moving forward with. As stated, even though I think we as prosecutors have a huge amount of work, as does our defense colleagues, we try to play that gatekeeping role. And as I'm sure the law enforcement community will tell you, they've had lots of conversations at different points in their career where they're like, prosecutor won't take my case. And that can be very frustrating. But I also think it's our important role to build credibility and rapport with law enforcement officers, that we're going to review everything so that a judge doesn't dismiss it later. The judge does find probable cause, because otherwise it's a waste of everyone's time and it doesn't help the defendant, the victim, or anyone else. So I understand what you're saying, and I think in an ideal world, we would never have to employ any of these types of tactics. But I mean, I know that these tactics are sometimes helpful, particularly in the investigations, as I've heard examples of that ICAC, the sex assault cases, where the pursuit of facts is not something that's going to happen on its own.
I'm sorry, I did remember my first
Go ahead.
question. This, we were also told that this basically codifies what's been in practice already in terms of the, I think that was referring specifically to like allowing what has been referred to as like the use of targeted deception, as long as it meets, the test here on page 6. Do you disagree with that? Does this, in your mind, actually go further than what is already happening?
Relying in part on some of the testimony I heard on the Senate side, if it would allow for the suppression of certain statements that would have gone in before this bill, but after this bill will not get in, then I think it would impact the results in some cases. But I have to rely in part on law enforcement providing that information to you because they're the ones that are, employing the practices. And I am on the Criminal Justice Council for the state's attorneys. I would say that I'm on the Fair and Impartial Policing Committee and the Domestic Violence Committee, and I sit on the larger council. And there is a sense, I think, that there's quite a few policies that, you pass a policy, you work on it, needs to be updated every couple of years, whatever the case may be. So that I do think there's an important reason to have maybe a person that works for the council full time to just help usher that type of work happening. And I remember the Senate Judiciary Committee talking about why they were putting that in. And I think our state's attorneys are in support of making sure that council has the tools they need to accomplish the legislative aims.
Thank you.
Sure.
I wanted to talk a little bit about confirmation bias. And sort of to what extent do you see confirmation bias playing a role or not playing a role in investigations, and then, in your sort of overseeing of investigations, and also when it gets to your point. And I'm just thinking of so many cases that we've seen in the media. We talked about the Central Park 5 case. I mean, there's a lot of bias and confirmation bias that went into that case of why the police officers went over those particular boys. And then once they got the confessions, they still stood behind their investigation, said, well, we have all this evidence. Well, it turns out that they really didn't. I'm thinking about Adnan Syed. I'm thinking about, much of the book, The New Jim Crow. I'm thinking about, I mentioned earlier, there was this case out of Laramie that there was recently a podcast on. It seems to me, in having read a lot of social science literature around the criminal justice system, that once you start going down a path, that path gains momentum. And so even when you have false confession situations, as there are many situations like this, I'm just really worried about that. Once you start leading down that path, again, it leads into confirmation bias. And I'm wondering to what extent you've ever seen confirmation bias playing out in a case where you had to say, no, we're not taking this, further because we don't think that this is a good case because there's been confirmation bias or something like that going on that has led law enforcement down path A instead of also exploring paths B, C, D, and E, et cetera.
I think it plays a role in all levels of government work, whether it's pursuit of a bill, whether it's pursuit of a case, whether it's pursuit of a certain policy. And I won't use too many examples from my time in the Treasurer's office, but sometimes national policies and policies that don't have many examples locally do take off here in Vermont. And as I start off with the example about my parents working on a case that would have been terrible, right? A confession was coerced, a person didn't have the faculties. But I do think our case law in Vermont helps to paint the pictures, all the relevant factors, the youth of the accused, level of education, level of intelligence, the extent of the accused with advised of his constitutional rights, the length of the detention, the repeated and prolonged nature of questioning, the use of physical punishment, and deprivation of food or sleep, combined with the Supreme Court now for the past 40 years saying that lies about incriminating evidence taken alone are not enough to make any resulting confession involuntary. And so all this to say, yes, confirmation bias plays a role. We are human beings. Once we start thinking about something being the way that it is, I think we want to be comforted by that, because otherwise the alternative is terrifying, right? It's, did I, do this or that? But prosecutors that are playing that gatekeeping role work with law enforcement, and also law enforcement works within their own ranks before we ever see things as well. And I have to say, I've seen examples of that, excellent examples of that here in Washington County, where they call you on the phone. They don't have the case ready. They want to talk with you about it. Or where they say, Tim, I really don't think that this case needs to result in a charge. Person confessed, but maybe we could just do this or that. We could sort it out. So I do think in Vermont, we are doing a decent job with it. Certainly there's examples, but I haven't heard personally of lots of examples where, a case was, we find out after the fact that it was all a ruse in terms of confirmation bias led to some result, but doesn't mean it doesn't happen. I think it's an important part of the work we're doing to be aware of that. You have to be aware of the confirmation bias. Totally, yeah. And the examples you gave are so troubling. The Central Park, case in particular is just egregious. Yeah.
Thanks. Any other questions for Tim? We may have more questions down the road, possibly. I think, Ken has a question. Go ahead, Ken.
Hey, Tim, if law enforcement is too, I'm right behind you, buddy. If law enforcement is too restricted to ask questions, that's really going to impede on really digging up enough evidence to charge somebody that needs to be charged. Am I wrong?
I think certainly when you're decreasing the tools that you can use, and they should always be based in best practices. But when you're limiting what you can do, as I said, there's certain examples where once the tool was taken away and it was available before, it could result in limiting a case proceeding.
So you just went to my next question. We're taking a major, because, the word being used, deception and all this stuff here. And it's like, I'm trying to think of different ways to go and try to get this individual to go and talk. You got to be very, very creative, because you're probably dealing in a lot of cases with masterminds. And I don't care if they're 17-year-olds, and we got some pretty clever 14-year-olds out there to go and get information out. And once this type of person knows what their limitation or what limitations are put on law enforcement, it's going to make that job much more tougher to go and prosecute, correct? Or even arrest, or even hold, or to get it to the district attorney to where they can go and do what they need to do, correct?
I know you all know this, but Vermont does have a very robust juvenile justice system for individuals in most of the age range that you were talking about. And I do believe that there is a lot of brain science that goes into some of the policy thinking behind the work. But there are circumstances certainly where there's a victim involved. The community is demanding justice and accountability, and a person might be 18, 19 years old, and that is something that, it's the toughest part of the job as a prosecutor to do that type of work, but it's certainly something that we take seriously when we are filing an adult criminal court for an individual that is, a younger person. It's
because the light bulb really went off in my head when you brought up that case of that school teacher years ago in St. Johnsbury. What somehow or another, I know a lot about that. actually, I do know why that took such an interest now. But it's like you had to be really, really, really clever with that whole case there, with that one there. And then there was another one, I believe, right up the road, if I'm not mistaken, with a younger, I don't even know if she was a high school student.
Yeah, I'm not familiar with
Kind
this.
of right after the school teacher thing, I think. And I think they had to be very clever of how they got information on that case too. And I personally think this bill hampers how we're going to get information. So I guess that's just a statement to you. The other thing I want to know from you is, what do you think about this, the 20 under 22? What do you, where's your where do you think we should be on age?
I really would want to talk with all of our state's attorneys on that. And the reason I've been hesitant to do so is because when the bill started, it was about 18. There was a discussion at one point of it being somewhere in a range or tying it to another part of statute. And then it settled on 22. So I'm not sure what to say about that. I do think that it's a larger population of individuals that would potentially, for lack of a better term, be caught up in this if it's up to 22. And just your policy call on how widely you want to open the door. And again, we don't know how many, I can't summarize how many cases would be involved here, but increases the exposure, I guess.
Okay, so
sorry to be vague.
You're not really being vague at all, because where I'm really, really struggling with this whole thing is we're going and saying that these juveniles and stuff, their brains aren't fully developed till they're like 25 and all this stuff. And I'm telling you right now, there's a lot of clever 14-year-olds that really know how to get around systems very, very well at a very young age. So this whole maturity, brain thing and all that stuff, yeah, I'm sure there's a lot of evidence out there for that, but there's two sides to every story as usual. So that's all I got. Thank you.
Thank you, Ken. Mr. Gosling.
All right, so thank you very much, Tim. Actually, I'm sorry. This is something for you to ponder a little bit. Sorry, Ken, for using the word ponder. Just I mentioned, if we were going to do some sort of a carve out for sex crimes or child sexual assault or along those lines, if there is some sort of enhanced gatekeeper role that we can actually codify for state's attorney as far as cooperation or something like that. I'm not expecting an answer right now because this kind of is coming out of the left field, but if you can think about that, and we can have you in to talk about that if that's an avenue that we're going down. All right, so I appreciate it. So we're gonna go with Matthew Raymond next. I know there's a couple people still online, but just for flexibility purposes, since we actually have Commander Raymond here, and the other folks are probably sipping a martini in their studies right now as they're listening in. Just kidding, Judge Zone and
So it is 5 o'clock somewhere. I know that.
Exactly. So hopefully we'll get to you guys as well before we're done. But I just want to make sure we got to your testimony as well. If you can identify yourself and proceed.
Yeah, my name is Matt Raymond, and I'm the commander of the Vermont Internet Crimes Against Children Task Force. So I run the ICAG for the state of Vermont. So I was asked to come here and just say how it would affect ICAC, and I think it's would affect the ICACs and the SIUs, and really as the current form, the 18 to 22-year-old population. We've seen a steady increase in cyber tips as I've come to this and testified about here before, and it has increased again, and so much so last year we had over 600 for the calendar year. Which is just astronomical numbers for us here.
600 tips or 600?
Yeah, it's just cyber tips from the National Center. That excludes cases from like DCF, parents calling in, what they found on their kids' devices, any of that. And they're all And we only accept cases primarily with adults on children. So the under 18 doesn't really affect us too much. It has to be a pretty high bar, pretty deep end of the pool for us to be dealing with a under 18 offender. And up until
Matt, before you go any further, pre-COVID, what were your numbers?
Probably I have all the numbers printed out, but I'm getting older and I forget faster now.
Well, you can send them to us.
I think they were like in the 300s just a few years ago. So we've just about doubled. I think they went like 3, 4, and then jumped to 6.
And let me confirm, 600 total or 600 in that range, age
There's
18 to 20?
No, total.
Total, all right, I just wanted to
say,
confirm.
just the numbers have gone up, and with the numbers of tips that have gotten up, in the last few years, we've seen an increase in the 19 to 22-year-old offender range, which historically we didn't see very many, and now we're seeing more and more. I think, although I can't, put my exact finger on it, but I think it's just platforms being just so much better at patrolling their environments and looking for this stuff. I think it's increasing the number of tips overall, and since the overall numbers are increasing, that age group is increasing just with everything else. So we do deal now a fair amount with the 19 to 22 kind of age range. But again, we don't typically deal with the historic juveniles under 18. So we do use deception in our interviews. The previous detective testified, it's not our go-to, but it's definitely in our tool bag of things that we use. I know SIUs use it. The concerning part to me is, 18 to 22 is basically your college population for the most part. A big problem at college campuses is date rape. Date rapes are a lot more prone to be late reported, which means no sane kit, no evidence that you can compare it to. And a very typical question to these people was telling them that we do have a sane kit, and to a suspect, obviously, someone that's been accused by the victim, that we do have a sane kit. If we collect your DNA and compare it, is it going to match? Typically in those cases, the person has denied any type of sexual encounter, and then they change their story when they realize that there's a sane kit, which of course in that scenario doesn't really exist, and then say, oh, I had sex with her, but I did not. It was consensual, and then that's a whole other part of the investigation. But it surely changes the case around using that. Deception for ICAC cases, and I don't know if people understand what we do. It's primarily goes into kind of 2 buckets. Well, the overarching ICAC, we have our mission is to prevent the victimization of children through the use of the internet or technology. And through that, we kind of have 3 legs to our stool. Investigations is one of them, and of course, that's what we're talking about today. Then we have forensics and education as the other pieces. But in the investigations phase, we have both proactive and reactive investigations. Historically, I should say, because recently, in the last several years, we've been just inundated with reactive investigations. So we don't do too many proactive investigations anymore, to be honest. Unfortunately, our goal is to get back there, but of course, we have to deal with all the ways.
I got a bill that'll help you.
So in the reactive phase, basically that's where I was getting to when I said there was 2 buckets of type of investigations. You have child sexual abuse material, and people think they always, unfortunately, people go to like baby in the bathtub or age difficult stuff. But when I'm saying that we're going out and charging 19 to 22-year-olds, we're not charging them with having a picture of a 15-year-old. These are infants and toddlers being sexually assaulted in videos. So it's very deep into the pool stuff. So they're very serious crimes, and that's something that's not going to go away overnight. So being able to hopefully intercede in these people's lives before they've gone hands-on with a child themselves is obviously our goal. And taking a tool away that might make us figure out who's doing it would be bad for us. So that's why I came to to talk
Yeah,
about.
Tom, then Joe.
So you're seeing that much of an increase in the 18 to 22-year-olds?
It's really, I'd say 19 to 22. If it's an age difficult case, we're not going to accept it for investigation because of we can't get to everything right now. So the numbers. So typically, most of our cases are under 8 years old. But we have seen an increase of toddler and infant victims with that age range. Yes. Sorry, if he's bothering you, I can move him. This is, if anybody wonders why I brought this dog with me, his name is Mojo. He's part of the task force. He finds electronics. He's been trained to find phones, SD cards, hard drives, stuff where electronic media. He's also sometimes obstinate, if you're sitting here now. I apologize.
No, it's always nice to have a
He's a
dog.
food reward dog, so he loves food. Anyway, sorry for that interruption.
No problem. Go ahead, Joe.
So you gave an example of a reactive investigation a moment ago. Maybe you got a tip regarding child pornographic material or something like that. Could you talk about how you would use deception in a custodial interrogation in that example that you just gave? Yeah,
so explaining how our tool, we have lots of examples. I don't really want to give out all of our playbook in a public atmosphere for, someone to use against us. So just some small examples are overstating what our tools are capable of finding, right? So if somebody has gone hands-on with a victim and we're interviewing them in a custodial atmosphere at that point, and then saying, okay, we found more stuff on your device. Can you tell me about the other incidences? Where we haven't found anything, but then all of a sudden they're naming a handful of more victims. And those are victims that typically have not complained, cried out for help, but need it. All the studies show that the faster the victim gets some type of treatment, intervention in their life, drastically better outcomes in their life are going to come from that. So our goal is to identify all the victims in the cases and get them services. And the faster we can get those services, the better. So unfortunately, we find, when reviewing these devices, evidence of hands-on. So we may have gotten a cyber tip on a file that we know exists out there. And when I first started doing this, we were talking, hundreds of thousands of known files. We're now, and I'm going to have the number wrong now, but I think it's like over 7 million identified files that are in the hash databases now. So, the problem has just gone exponential. So, and again, it's targeted deception on a case by case basis. It's not, done willy nilly or done in every case. So these are cases that are, people unfortunately ride a roller coaster of their urges build up. They do the crime, then they feel hatred, self-hatred towards themselves. This isn't every case, but this is a predominant amount of them. They feel self-hatred towards themselves. They don't want anybody to know. Their intimate partners don't know. Their parents don't know. This is the first time they're going to be talking to another human being about this. So we use a fair amount of mitigation, not legal mitigation, meaning that you're not going to get in trouble. You can tell. Obviously, that's forbidden. You can't do that. But explaining, I understand your urges, where I clearly don't understand their urges. I'm not sexually attracted to toddlers and infants, but being able to develop a rapport with these people is another form of deception that we're using with these people.
Thank you.
Angela.
Hi there. I want to understand a little better, and I don't want to make any assumptions. So can I ask you to share a few other tools in your toolbox, like just broad kind of categories, so that I'm not asking you to give away trade secrets?
Yeah, so it's kind of hard because our investigations are so broad. You have to realize that all the different, when I first started doing this many years ago, there wasn't a lot of platforms that people operated on with this stuff. There wasn't, you can imagine, think of all the different things you can think of right now that didn't exist a decade ago, right? So it was fairly easy then. There'd be usually a big tower or desktop computer in someone's basement, that they were doing this stuff on. And now it's, everything could be in the cloud. You could be just using cloud services. You could be using VPNs and Tor to obscure your identity. So, it's hard to say a typical investigation of ours because nowadays they're so different. One day we're doing a Discord investigation. The next time, it's an online gaming where someone has been victimized. It could be as simple as a Google Drive where they keep their stuff in their Google. So our investigations are so varied. There's not really like a typical one, so some of them, there's like a plethora of evidence leading to the person and they've taken selfies of themselves and you know who it is before you even drive up to the door, right? So the interview in that case isn't very important on the known crimes, right? The question is the unknown crimes. Have they gone hands-on with the child, and is there a child out there that needs to be identified to get services? And in that's where the cases where deception can come in to say like, okay, we're finding concerning things. Have you touched a child inappropriately? And then they admit sometimes that they have, even when we don't have the evidence of it. Much different than like has been testified here before, keeping people in custody for long periods of time and planting ideas in their head. Clearly not doing any of that stuff. And I know of none of that going on in Vermont.
Yeah,
we work across the state with almost every, because we're right across the street here, or right across the whatever it's called parking lot at the Attorney General's office, but we don't obviously bring our suspects back here. We use police departments all over the state, wherever we're closest to the defendant, to bring them to and use their stuff. And I don't see there's just horrific incidents of this that we've seen historically and nationwide. No disputing any of that. I just don't see it going on here in Vermont. There's a lot of different guardrails in Vermont than they have in other states. When we do have a case that involves, which is, an extreme minority of our time, that involves someone under 18, then you have to have a parent that's or parent or guardian or a person that's interested in them and disinterested in you. They have to have time to talk alone. It's very heavily scrutinized by the court at that point. So there's a lot of guardrails in this state that don't exist in other states as well.
So, and I think what I'm trying to get a picture of, or some understanding of, is, I don't know why this is the analogy that's coming to mind, but I'm picturing the dentist's office. And probably because it's close to torture, right? But when you go to the dentist's office and they bring out their little tray of tools, I'm going to say, you can no longer use this tool, and it's the whatever little scraper thing, they still they can probably still clean my teeth. It might be a little harder, but I'm wondering, like, what's left on your tray?
So I think
say no more deception.
Right. So obviously there's, you're having conversations with people, and every conversation with people is different depending on who you're talking with and what you're talking with them about. So, and like I said, all of our investigations are so varied. We don't have an in the can interview, right? But what I can say is taking deception off that tray will leave unidentified victims on the table. So we will have kids out there that need services that aren't getting them without having that tool.
Thank you.
Other questions? I don't see any right now, so we'll move on. Did you have more?
The only other,
oh yeah, go ahead, please.
So my two recommendations would be moving the age back to 18 or making a carve out for Title Chapter 6. I can't talk all of a sudden. Title 13, Chapter 64 of the exploitation chapter for children.
Right.
So,
yeah, go ahead.
Did I understand you earlier that the ICAC or your office deals with like the date rape type things?
No, I'm saying we work with SIUs across the state.
Okay.
Gotcha. So, and a lot of our people that are the ICAC investigators have a background in SIUs. So I can speak to that as well. I was just throwing that in my hat in that ring as well.
Right. And I guess kind of know what your answer is going to be, but I guess just say a little something on maybe a carve out for those types of sex crimes also.
Yeah, that's the whole reason I brought it up.
General. And another thing that comes to my mind is human trafficking. I mean, you know,
I know I've heard that goes hand in hand. But yeah, I just heard a reluctance to knock it back down to 18. I just wanted to point out that through SIU stuff, you know, it's the entire college population. And date rape is a real problem. And late reported date rapes are a problem because there isn't any other evidence like there is, like the detective was talking about on, you know, when they bring out to a homicide, the whole, search team. That doesn't exist with a scene that no longer exists and evidence that has been long washed away. So sometimes there's no other, alternatives other than interviews. And sitting down and saying, did you do it? No. Okay, thank you very much. Doesn't really work.
Go ahead, Ken.
Thank you. I probably missed this earlier. How many people do we have in ICAC right now in the state?
So it's kind of a complicated question to answer. So there's 4 of us that are full-time out of the Attorney General's office. Then we have federal, state, county, and local officers assigned to us on an either full-time or part-time basis. And that changes very fast now in Vermont with losing law enforcement left and right, and then people being promoted or moved to other, other necessary places. If a police department that was supporting ICAC with an investigator loses too many people, they have to patrol as their first place they have to fill with people calling and saying, I need a police officer here. So we lose and gain on a routine basis. So that's a kind of a moving target, but the state only pays for 4 full-time investigators.
So I got sidetracked here. Just to make sure I heard correctly, we only have really 4 full-time officers in ICAC that are fully employed by the state of Vermont, correct?
Correct.
I think we need to look at that. Thank you.
I would appreciate it.
Yeah. H441, I understand. Any other questions? Thank you so much for.
Thank you very much.
Patience for being
Yep,
here.
no problem at all. Thank you for having me. Sorry to leave like a mess there.
Yeah. And we'll go to Christopher Brickell, please.
Thank you.
Thanks, Matt.
If Christopher's still, yes, I think there you are. Great, excellent. If you identify yourself for the record and proceed with your testimony.
Absolutely. Thank you. For the record, Christopher Brickell, Deputy Director of the Vermont Criminal Justice Council. And I have to say, this is the first time I've had the honor or the privilege to testify before your committee, so I appreciate the invite. I will say it's kind of tough to bring your testimony when you've been upstaged by the thought process of a martini being sipped someplace and a dog that upstages you before you even testify. So having said that, I don't want to take a lot of time of the committee, but I want to get my points across. But I have to give you a little history first on the council. As you know, the council has been reestablished with 24 members now, as opposed to 12 members as it was in the past. And over the years, we have been tasked by the legislature to create statewide model policies for agencies to follow and for agencies to be accountable for. One of the very first ones was a fair and impartial policing policy that I was actually involved in the drafting of that policy. And I can tell you that it took several months to do that. That was in conjunction both with the AG's office, Human Rights Commission, ACLU, Migrant Justice, and other interested parties. And that, after the development of that policy, went before the council for one of, I think, the longest in history council meetings to actually get it to be approved as a model policy, because there was a lot of input and interest in that policy. And so having said that, I want the committee to know that FIP, Fair and Impartial Policing, is just one. We also have an internal affairs policy, a body worn camera policy, the use of force policy, race data collection policy, one that's being developed right now, a domestic violence involving law enforcement policy that's currently going to be under construction. So this is one more policy that the legislature is rightfully looking at, and the council is not only honored but appreciates the ability to weigh in on and be responsible for these policies because they affect all of law enforcement and their ability to investigate crime and to work with populations that might have been disenfranchised before. So one of the things that's important to note is that we have been historically level, sometimes even underfunded in every aspect. And when I initially gave testimony on this subject in Senate Judiciary, there was I think a misconception early on that the council had a policy director, which is why initially in my testimony, I said, boy, these are awful tight timelines in order to get this work done. And in order for the council to get it done to the committee's satisfaction, we want to make sure that we're doing this right and we're hitting all the marks and getting all the pieces done. Having said that, that's where the appropriation came from initially for a policy director. And then when we got to Senate appropriations, that magically disappeared. And now we're back here in House Judiciary for another different review of this bill. And I just think it's critically important that the committee understands the amount of work that goes and will go into developing this policy, making sure that agencies are compliant with it, our review of that policy, and then the biggest part, which is training. We're going to be responsible to train individuals to this policy to make sure that they adhere to it, that it's followed, and that there's compliance from all law enforcement agencies, especially when you're incorporating things like whether you're contemplating whether deception can be used or not, and you're contemplating all populations. So having said that, I'm looking at the timelines and notice that October of 23 is when the council and the Attorney General's office must create the policy to begin with. I see you shaking your head no. Is that incorrect?
No, I was shaking my head because there's no way.
Oh, okay.
So I didn't mean to jump ahead of where you probably were going. But I will ask a really quick question. Two questions. What is a reasonable date if we actually can get an additional person to be working there on policies? Number one. Number two, what would be a reasonable date if we can't get that additional person to work for you? And maybe you don't have that right off the top of your head, but that would certainly be helpful for us going forward.
I don't have that answer for you going forward, but I do think it's reasonable knowing the council's willingness and the ability of us to reach out to our stakeholders and get them involved early to look at the date of the January 24, where we would have been required to update that policy, including stakeholders. And I don't think that it's an unthinkable idea for all of those stakeholders to be included in the initial development of that policy, as opposed to setting one stage for just the Attorney General's office and us to come up with a model and then update it just a few months later to include all the stakeholders that would want to have a say in this policy. It would make sense to me to include all of those people right from the beginning, because we're going to need subject matter experts that can really weigh in on this, especially if we don't have a policy director in place right off the bat.
And Ben, did you note that what he just said?
Yeah.
On that? Because I think that makes a lot of sense. That will
so just to clarify, essentially strike the provision about October 1 between the AG and the Criminal Justice Council and just have it be all the stakeholders listed for the January 1st, 2024 adoption or establishment deadline.
Right, and it would also obviously include that applies to all person. Well, it applies to all persons subject to various forms of interrogation, including that language, obviously. And I think we're going to probably be getting a recommendation from Tucker Jones as far as a couple additional stakeholders that will probably include in this, but he's going to send us something. So just wanted to flag it. Sorry, Christopher, I just wanted to get that to our legislative council because that makes a lot of sense, and I don't think we're going to have too much opposition to that idea in here.
Sure, well, thank you. And I just think that those other timelines rolling forward from that then might need to be adjusted in the fact that once that policy is adopted, prior to agencies actually just adopting it and putting it into place, they're going to need to have some training on that policy. And that training is going to have to be developed. And all of our training is, as you know, we're looking at our entire curriculum review that has been, supported so far in the governor's recommended budget, which is a 3-year process that we were looking at. Not that this policy should take 3 years by any means, but we're really looking at going to competency-based training as opposed to what has been typically mandated to us before of hours-based training, which does not in a lot of areas make sense. We've had several areas where we have hours of increments for a specific type of training, and the legislature sometimes felt that there was more addition, so they just added more hours rather than really had a competency base. So we want to make sure that we're going to be training this to a competency level that agencies understand the policy, they feel comfortable with it, and they know how to put it into practice so that there aren't violations of those policies.
So I see those in section 6, I believe, of this, the various dates. Could you send an email by way of Panina, our committee assistant, on what you think reasonable dates are for that rollout?
Absolutely, I could.
I appreciate it.
Thank you.
Yeah, and we'll have Panina send it down to you. Yeah.
And so I think, just lastly, I think I wanted to make sure that everyone was, appreciative of the fact that this will also include a requirement that we report out annually to both House and Senate on where we stand and where this policy has been going. And we're also going to be responsible for compliance with agencies. So we're going to have to check that either they have adopted this policy or at the very least all of the major components of this policy so that they will then meet the criteria of the section that will impact them as far as grants or their ability to use the Academy services if they're not compliant.
Okay. So do you have I didn't catch that entirely. Did you have a suggestion on that? I apologize, Christopher.
No, I think what I would like to do is between the executive director and the chair of our council, you have a quick conversation with them about what are realistic dates that we think, then I'll certainly send them to Panina and forward them to the committee.
Yeah, I appreciate that. And Panina can send them we'll post it and we'll send it to us and to Ben. Angela has a question for you.
Absolutely.
Which is a surprise to everyone here. I really appreciate your input, and I think that it's really important to hear from you and to hear from maybe others on the Criminal Justice Council, because you'll have a big job before you should this bill pass. And I'm wondering about what you just referenced appears on page 10, lines 12 through 15. You mentioned the report back to the House and Senate committees on Judiciary. And there was a little bit of discussion this morning about how this section really is encouraging the council to track training, but not necessarily use or implementation. Do you have any thoughts on that, on the ability? I don't even know if it would be the council's responsibility, but if we're trying to understand both that this model policy is that folks are being trained on the policy, but also ensuring that it's being implemented. How do we do that?
Well, I think how the council would report out would be on what that policy has encompassed, the type of training that the council has provided to the law enforcement partners that would be beholden to this policy. I don't think, unless it is somehow specified in this legislation later, how we would be able to report on the type of training or interrogation methods, because unless that is specified within that policy, agencies will use either a collective group of different types of interview techniques or trainings that they go to now. There is the Academy model is the PEACE model, which is, you've heard likely another testimony, is the training that the Vermont State Police train to, but there are clearly other methods, Reed and others, that other agencies use and continue to utilize. And while there are some who feel some are better methods than others, as I think you've heard testimony as well, a lot of investigators or people that are interviewing people use bits and pieces of different types of training that they've gone to. So it wouldn't be incumbent upon us, I think, to report on the actual method of interrogation or interviewing technique that they're doing.
So wouldn't it be the model policy that is being developed that would be trained to?
The model policy would be correct. I don't know as you're outlining the specific type of training in interviewing or interrogation.
Okay.
So I guess that's my question then. I maybe was working under the false assumption, it sounds like, that the model policy would become sort of the standard, the expectation. But I'm hearing you say that there are a number of, methods and techniques that you can't specify that, okay, now this is the one to be used and adhered to. So I understand if that is the case, I understand why that would be then very difficult to track the actual implementation of the model policy, but it is tied to this grant money, right? So there's some accountability.
As I read the legislation, the accountability is whether they have adopted the policy that would be created by the council, whether they maintain that as part of their operational policies, whether they continue to maintain it and it's updated and they have it in place and they're adhering to it. So as I read the criteria of the policy, it is based on forms of interrogation that include custodial interrogations, both in custody and outside of custody, interrogations that are not considered custodial or regardless of their location, and then the wide bucket of interrogations that include individuals with developmental and intellectual psychiatric disabilities, substance use disorders, and low literacy levels. So I don't know that you can take one model of interrogation or interview, whichever term you're going to use, and train to encompass all of those dynamics within what you're looking to encompass. If you're looking for a policy model that specifies what type of interrogation uses, I'm not reading that in this legislation, nor am I suggesting that you do that.
Right.
Gotcha.
Unless you're, I'm not seeing something that you've drafted or intending.
No, I think you see it. I think you just have more knowledge about how this actually plays out than I do. So it's very good. It's helpful to appreciate what you're saying.
So don't you have, like with the fair and impartial policing policy, on an annual basis, or isn't there somewhere they have to check off that they have that kind of policy? I mean, isn't that something you would know whether a law enforcement agency actually has adopted the policy?
There's a requirement under Rule 13, which are their mandatory training standards that each agency has to attest to the fact that they have that fair and impartial policing policy in place, and it has to either be the council's policy, or it has to be a policy that it has all of the components of the council's policy, and they can include additional protections, so to speak, if they choose to do that, as long as it's been reviewed by the Attorney General's office and it meets the criteria. So yes, there are those checks and balances, and that would be similar to this policy, is that each agency would have to adopt this policy or a policy that included everything that is listed in the legislation as it comes out and what the policy is written as. And then if they wanted to add additional safeguards, so to speak, they could likely do that as well. But that would also be a component of ours, is that we would have to make sure and check with these agencies based on the legislation that they actually keep this policy in place and they're adhering to it.
Right. So that's a Rule 13 attestation that they have to do annually anyway. I guess this doesn't have the same kind of check like we have for the fair and impartial policing policy, that the AG would actually make sure that it follows the model policy. I don't know that we necessarily need to deal with that right now in this bill, and maybe down the road, once we see what the policy looks like, maybe we have to add some sort of a check on that. But
Ben's got a hand up.
Oh, I'm sorry, Ben. Yeah.
It does have that check.
Oh, it does. I must have missed that.
they have to check to ensure that it's.
Who's doing the check?
The council.
The council is, okay.
And the AGs, and I believe that there are other stakeholders as well.
Okay.
Human Rights Commission.
I missed that.
And then update it if it's necessary.
Thank you, Ben. I somehow went past that. Okay, anything else that you want to weigh in on, Christopher, or any questions?
None for me at the moment, but I will certainly review those dates. We'll get them out tomorrow to the committee so that you have the dates suggested by the council on what does appear reasonable and who those the timeframes of who the stakeholders should be in there.
Great, I appreciate it. Thank you for your time.
Can I just get really clear on this?
Sure, we have one more question.
Really quick. So I'm reading section 6. The heading of section 6 is statewide policy interrogation methods. Is that a bit of a misnomer?
Actually, it is. The way I read that, interrogation methods, it's spelling out.
Okay, that's what I thought.
It should say statewide policy interrogation guidelines, parameters, model policy.
Okay.
But to say interrogation methods might be a misnomer.
Okay, we'll flag that and think about that. Think about that, Ben.
You already did.
All right, thank you so much, Christopher. And Judge Zone, thank you so much for your patience. I hope you got lots of other work done as you were waiting for us to get to you.
Good old fashioned lemonade. Nothing more.
Oh, okay, fair enough. Fair enough. Sorry to hear that.
Very good. So for the record, Tom Zone, Chief Superior Judge, I will not repeat everything you heard here today, but as I often will say, this bill really talks a lot about policy. And as I was watching the presentations today, it was really Representative Arsenault's comments that I think drove that home this afternoon when she was asking about, well, wait a minute, if judges can't be deceptive and the state's attorneys can't be deceptive, why can police be deceptive? And I understood her to be wrestling with that. And that really is the type of essence of the policy that you have to address when you're looking at this bill and decide where does the committee want to go. One of the aspects of that policy is the age. And we've heard quite a bit of testimony. And is it going to be 22? Will it be younger? Whatever policy is adopted is going to have a potential impact on the judiciary. And as I was listening to the testimony today, the question I kept thinking about was, have I ever had a case that I actually thought would fit within this bill? And I can't think of one. That doesn't mean that I may not have had a case that because this bill was not in effect, someone did not pursue for that, youth under age 22. But I could not think of a case where this was an issue, if you will, that was front and center. And I checked with another judge who also was of the similar idea. And while we could think of some cases with adults, perhaps, that this would have come up, we couldn't think of anything of the under 22. Do I think that the bill, if it's passed and signed into law, would have an impact? I'm sure it would. I'm sure we'll see more. But I don't see it being a huge number, whatever the number is, the judiciary is going to keep up with and analyze as we do with all cases. And the one other thing I wanted to touch on, there's been talk about a carve-out. And I think Detective Raymond talked about that, and Chair Lalonde, you mentioned consideration of that. That's a policy decision, obviously. But I would just ask the committee, if you're looking at a potential carve-out, to think about that, because an interrogation can certainly start off one way with one crime and take a much different direction. Mm-hmm. And well, what if the case starts off with a carve-out, goes into something else? Well, what if it's the opposite of that? And then, well, wait a minute, what cases are you going to carve out? Well, that's a policy decision. And so do we carve out domestic assault in addition to the sex cases that Detective Raymond talks about? Do you carve out aggravated assault with a weapon, perhaps? And so I'm only suggesting that the committee look at that and really consider, do carve-outs really work? Or do they oftentimes lead us to come back in subsequent legislative sessions saying, well, what about this one? Or what about that? That should be included. And so I just put that out there for the consideration of the committee as it thinks about its policy. And I've heard testimony today, and I understand the testimony about the difficulty of the higher standard. I think it's been said about, well, if it's clear and convincing, that's a more rigorous standard. Whatever standard, if it's preponderance, which it currently is for voluntariness, or if it's a heightened standard of clear and convincing, the judiciary will do what we do, and that is decide the cases based upon the facts and the law that the legislature has enacted. So I'd certainly be willing and happy to answer any questions.
Joe?
Thank you, Judge Zone. You said a moment ago that you couldn't think, either yourself or another judge you spoke to couldn't think of a single case where this was front and center. But then you said that you could think of cases where this would have been front and center involving adults.
I was thinking, in particular, I thought of one case where it would have, I believe this was an issue that was raised as part of the filings.
Other questions for Judge Zone? I don't see any at the moment. We're all just pondering what we learned all day. Thank you, Ken.
I gotta find out what the story behind that is.
If you have any, if there's any further questions you have, and whether you'd like me to come back or just see me or email me, I'd be happy to address it and help you out.
I really appreciate it. Thank you for your patience today as well.
My pleasure. Have a great day. Stay safe, everyone.
All right,
Thank you.
Thank you.
All right, so we have certainly one, Marshall testified earlier. I don't know if you were in there. Marshall testified, yeah. So Ruth Whitney, we need to bring back Middlebury Police Department. I am thinking we should probably talk to Sarah Robinson and Jennifer Pullman to get their perspective on this as well. And then we do, I think, need some conversation on this one in the committee, because I have a feeling there's very different places on this particular bill. And,
could we interrogate each other using these?
Yes, that'll be fun.
Half of us will use one technique.
Yeah, go through the chair. So in any event, tomorrow we're just, what are we at? S3 and S14 and
We get posted, let's pull something off the wall tomorrow.
Yeah, we'll
It's
pull
just
something off the wall
something
just for
easy. We just have a big kumbaya moment.
man, there's none of that with these, is there?
Oh, yes.
S14,
Trust accounting.
S14 should be that.
Yes, I think it's.
Uniform Trust Accounting Act.
What's that?
Uniform Trust Accounting Act.
There is always that.
Controversial.
All right, so we're gonna adjourn